Hi Anu, your favorite teacher is back with another episode of the Best Polity Lecture. So today we are going to be studying about पंचायती राज system. तो चलो थोड़ा पंचायती करते हैं इसके बारे में. So basically why we are studying this Panchayati Raj? What is the significance behind it? Significance is rural local self-government to build a democracy at grassroots level. Now who establishes this rural local self-government? All states established through acts of the state government. And this rural local self government helps foster rural development. This is the significance. Now let's see the evolution of that. So basically, the first recommendations were given by Balwantrai Mehta Committee. It was constituted in January 1957 and it gave its report in November 1957. ये dates याद रखना ज़रूरी नहीं है. I'm just telling you just for the context. What did this Balwantrai Mehta Committee do? They examined these two programs, Community Development Program and National Extension Service Program. They examined them and gave the following recommendations. So basically they told to have a scheme of democratic decentralization and establish a three-tier system at village, block and district level. At the village level there will be Gram Panchayat, block level there will be Panchayat Samiti, and at district level there will be Zilla Parishad. And he told that at the Gram Panchayat, members should be directly elected, and at the Panchayati Samiti and Zilla Parishad, they have to be indirectly elected. This is what he recommended. Another recommendation was the planning and development activities that has to be entrusted to this three-tier system at all the levels, village, block and district. Okay, I will be referring a village as village, block and district like this, VIND, okay, for convenience for all levels, just for telling that. Then it also recommended that Panchayati Samiti should be the executive body and Zilla Parishad should be the advisory, coordinating and supervisory body, and district collector should be the chairman of this Zilla Parishad. And one more recommendation was there should be genuine transfer of power and resources to enable the Panchayati Raj systems to discharge their functions. This recommendation was accepted by National Development Council in 1958, and after this Rajasthan became the first state to implement this in the Nagaur district. October 2nd 1959 में हुआ था. After that Andhra Pradesh also implemented this. Now this implementation of this Panchayati Raj differed from state to state in terms of number of tiers, Samiti composition, tenure, composition and function. For example, in Rajasthan there was three-tier system, but in West Bengal there is four-tier system, and Tamil Nadu two-tier system was there. Okay, now Rajasthan and Andhra Pradesh, in those two states, no, Panchayati Samiti was made very powerful. They were given planning and development activities. It was under them, Panchayati Samiti. Panchayati Samiti is the block level. We saw here, no, block level. They were made to plan and do some development activities. Then in Maharashtra, Gujarat, Zilla Parishad was powerful. In that district was given as the unit for planning and development. Okay. Then states also had to make Nyaya Panchayats to deal with civil cases and criminal cases. Okay. Then after this, Balwantrai Mehta Committee, many study teams was being formed. You can see in Lakshmikant table 38.1. There are so many from 1960 to 1976. So many committees are being formed. We don't have to study them. You just can look into it once. Okay, then we'll see Ashok Mehta Committee. This was established by Janta government. So this was instituted on December 1977, and they gave the report on August 1978. So they said that we have to revive and strengthen the Panchayati Raj institutions, and they gave 132 recommendations. They said that this three-tier system should be converted into two-tier systems. What are these two tiers? It has to be Zilla Parishad at a district level and Mandal Panchayat for a group of villages having population of 15k to 20k population size. Okay. Then another recommendation was district should be the first point of decentralization and state will supervise this district. And in this district, there will be Zilla Parishad, which is the executive body for planning and development. Then political parties also should participate in this Panchayati Raj institutions. And Panchayati Raj institutions should be given powers of taxation. Then there has to be social audit whether the funds are being spent for the vulnerable sections or not. Then state government should not supersede the Panchayati Raj institutions. Then elections should be held within 6 months from the date of supersession. Supersession means if they are dissolved. If they are dissolved, within 6 months they have to conduct election. Then Nyaya Panchayat has to be established as a separate body. Then Chief Electoral Officer, in consultation with the Chief Election Commission, should organize Panchayati elections. Then voluntary agencies should be there to mobilize support in order to get more people involved in the Panchayati Raj institutions. Then there has to be a Minister of Panchayati Raj to be appointed in the State Council of Minister. Then SC/ST seats should be reserved. Then there has to be constitutional recognition to the Panchayati Raj institutions. Okay, but all of these recommendations by Ashok Mehta committee could not be implemented because Janata government collapsed. But however, 3 states could implemented this. They were West Bengal, Karnataka and Andhra Pradesh. After this came one more committee, Dantwala committee in 1978. They recommended block level planning. Then came Hanumanta Rao committee in 1984. They recommended district level planning. Under this, there will be district planning bodies headed by the district collector or the minister, and district collector will be the coordinator for planning and developmental activities. Okay. After that came GVK Rao committee. This was in 1984. Now 1986. 1986 में okay, planning commission appointed as GVK Rao. And what did GVK Rao committees recommend? To review the administrative arrangements and poverty alleviation in rural development. Review the administrative arrangements for rural development and look into the poverty alleviation. What is the conclusion? What conclusion they came to? They told that this development process was heavily bureaucratized and it was diverged from Panchayati Raj. So this development process was against democratization of Panchayati Raj. Panchayati Raj institutions was made very weak. It was he told that it was grass without roots. So he gave recommendation that you have to give importance to Zilla Parishad. Zilla Parishad will be the principal body for planning and development activities and implementation and monitoring as well for rural development programs. This planning and development will also be done by the rural lower levels of the panchayat, but Zilla Parishad will be the principal body. Then state level planning functions should be transferred to district level planning units. Then district development commissioner should be created. This commissioner will act as the chief executive officer of Zilla Parishad and he will be in charge of the development department at district level. Then election should be held regularly. Okay, these were the recommendations of GVK Rao committee, but this was not being implemented at all. Then came LM Singhvi at 1986, just 1 year after Rajiv Gandhi made this committee, LM Singhvi committee, and they were asked, they made a concept paper, revitalization of Panchayati Raj institutions for democracy and development. This committee said that Panchayati Raj institutions should be given constitutional recognition and they have to be protected and preserved. And in this Panchayati Raj institutions, there has to be free, fair and timely elections. And for giving constitutional recognition, a new chapter should be added in the constitution to establish their identity and integrity. And there has to be a Nyaya Panchayat for a cluster of villages. Then village should be reorganized so that Gram Panchayats are made more viable. Then village Panchayat should have more financial resources, more money they should get, village Panchayats. Then these are individual states. Each individual states should have a judicial tribunal which will adjudicate into the elections of Panchayati Raj institutions, dissolution, or any other matter. Okay, this is what LM Singhvi gave recommendations. Then came Thungon Committee in 1988. I think 2 years later. 2 years later. So subcommittee of Consultative Committee of Parliament constituted this Thungon Committee, as Thungon is the chairman. So Parliament is constituting this committee here. What did this committee do? It examined the political and administrative structure for district planning. It said that you have to strengthen the Panchayati Raj institutions, give constitutional recognition, establish a 3-tier system. Zilla Parishad should be a pivot, means very important for planning and developmental activities. Then fixed tenure of 5 years, and in case of supersession, within 6 months you have to get elected. Then planning and coordination committee should be established at state level, and in that committee, the chairperson should be from Ministry of Planning. Minister of Planning will be the chairperson, and the members will be presidents of the Zilla Parishad. Zilla Parishads, like this is the state, so many Zilla Parishads are there. Presidents of each one of them will be the members of this committee, and there has to be a detailed list of subjects incorporated in the constitution, like that 7th schedule, like that we have to have detailed list of subjects. Then reservation at all tiers. All tiers means VID, village level, intermediate level, and district level, based on the population, for not only for SC and ST, for women also. Then State Finance Commission should be established, and the State Finance Commissions will give criteria and guidelines for the devolution of finances to Panchayati Raj institutions. Then there has to be a district collector who will be the chief executive officer of the Zilla Parishad. This was the recommendations given by Thungon. Then came Gadgil, 1988. In the same year, Committee on Policy Programs was instituted by Congress that time, and this committee was asked a question on how best the Panchayati Raj institutions could be made effective. The committee responded by telling the following: give constitutional status first of all, then establish a 3-tier system, then term of the Panchayati Raj institution should be 5 years, then members at all tiers should be directly elected, then reservation should be given for SC, ST, and women, then Panchayati Raj bodies should be responsible for preparation and implementation of plans for socio-economic development. Then there has to be a list of subjects. Then Panchayati Raj institutions should get the power to collect, levy, and appropriate tax and duties. Then State Finance Commission should be established for allocation of finances. Then State Election Commission to be established for conduction of election. So this was more or less the same recommendations as Thungon. Okay, then based on this Gadgil committee report, a draft for an amendment bill was being made. Now let's see how it got constitutionalized. Basically, Rajiv Gandhi introduced the 64th Constitutional Amendment Bill in 1989, July-May. Then in August, Lok Sabha passed it, but Rajya Sabha did not pass it because of some political reasons. So it failed here. Then came VP Singh government, that is the National Front government. It was instituted in November 1989, and in June 1990, it held a conference with all the CMs of all the states. So after this, in September 1990, the Constitutional Amendment Bill was introduced. But what happened is VP Singh government falls. So this bill also collapses. Then came PV Narasimha Rao government. Narasimha Rao deleted the controversial aspects of this bill and introduced it in the Lok Sabha in September 1991. This fortunately became the both Lok Sabha and Rajya Sabha passed it and became the 73rd Constitutional Amendment Act in 1992. Precisely, it's 24th April 1993 it came into force. This is just a detailed thing on how it got passed. In 22nd September 1992, Lok Sabha passed it. Then in the very next day, Rajya Sabha passed it. Then after that, 17 states have to approve it because federal character is being affected here. Okay, then 20th April 1993, President gave the accent, and after 4 days, it came into force. Okay, now let's discuss about 73rd Constitutional Amendment Act. So it added this part 9 called the Panchayats. And in that part 9, there is from Article 243 to 243O. It also added 11th schedule, which contains 29 subjects. And this 11th schedule is related with Article 243G. Now, what is the significance of this 73rd Amendment Act? It gave practical shape to Article 40. What is Article 40? Organize panchayats, village panchayats. This is Gandhian, no? In DPSP, there is 3 types, no? Gandhian, liberal, intellectual, and then one more is there, socialistic. This is Gandhian. Then it gives constitutional status to Panchayati Raj institutions. So what is the implication here? They are justiciable now. The state governments are obligated to make Panchayati Raj institutions. Okay, and the formation and election does not depend on the will of the state government. Okay, and also the act gives 2 provisions, compulsory provisions and voluntary provisions. Compulsory provisions, they have to implement it using the state laws for creating Panchayati Raj institutions. We'll study about this later. And then voluntary provisions, discretion. It depends on the state whether they want to implement that or not. It depends on their local factors like geographical, political, administrative, or others. Okay, basically this Panchayati Raj institution was a significant landmark for the evolution of grassroots democratic institutions. It converted a representative democracy to a participatory democracy. Okay, then let's see the salient features now. There are a lot of salient features. Let's see one by one. So it establishes the Gram Sabha. Now in that Gram Sabha, there will be people from, who are these people? They are registered in the electoral roll of the village. Only those people will be part of that Gram Sabha. Then that Gram Sabha will have a village assembly of registered voters. Nothing but, in other words, just village assembly of registered voters. Then powers and functions are exercised as per state determines. Of the Gram Sabha ka powers and functions are exercised as per the state determines. Then the structure में it will be a 3-tier system where the panchayat will be established for the village level, for intermediate level, and for a district level. Now, what is the meaning of village? Who defines this? Village means a village specified by governor by a public notification. And also the same goes with the intermediate. Intermediate means that kind of an intermediate which is specified by the government by public notification. Intermediate is between village and district. Okay, and this intermediate is not necessary to have, like, it's not compulsory to have this intermediate level. Suppose if the state population is less than 20 lakh, no need to establish this intermediate level panchayat. Okay, from now onwards, I will represent village as V, intermediate as I, and district as D. You can see here like that. Okay. Now another salient feature is election. Election to chairperson and election to members. Election to chairperson at the village level will be elected as per state legislative assembly. Whereas for intermediate and district level, it will be elected indirectly among the members. Okay, who are the members at the village, intermediate, and district levels? They will be elected by the people in that respective level, directly elected. Okay. Then Article 243F will prescribe the minimum age for contesting elections, which is given to be 21 years. Now reservation for all the three tiers, VID. Reservation is given to SC, ST, women, and also OBCs also. But I'll come to that. That is given here, OBC. First, SC, ST will see. They will be given reservation proportion to their population. Okay. Then State Legislative Assembly will make reservation of office of the chairperson. Chairperson के लिए State Legislative Assembly will make reservation, but this reservation will cease to have effect after the period specified in Article 334. In Article 334, it is written till 2030. Okay. Then this SC/ST reservation is not applicable to Arunachal Pradesh because there is already tribals residing there, and there is no scheduled caste. So by the 83rd Constitutional Amendment Act of 2000, this was being made. It was not being applicable to Arunachal Pradesh. Let's see for women. The Act specifies reservation of not less than 1/3 of the total seats. Okay, but total seats including women of SC and ST. Now suppose there is a woman. Okay, she is an SC. Will she be given reservation as a woman or as an SC? Actually, she will be given reservation as combination of both. That is what is the meaning of this including women of SC and ST. Let's say this is the total number of seats. It's divided into three. Let's say 3 divisions are being made. 1/3 of them will be given to women. Now, according to this provision, SC/ST will be given reservation according to proportion of their population. Let's say this much is the reservation given to SC and STs. Now, in that SC and STs also there will be some women. Right now, this is that woman here. Okay, and I hope you understood this. Then, reservation for chairperson. Women also will be given reservation in for the office of chairperson also. For how much reservation will be given? More than 1/3 of the total number of offices of chairperson. Okay. Then, yeah, this act also provides for that State Legislative Assembly will provide reservation for the seats of members and office of chairperson for other backward classes. But State Legislative Assembly has to make that provision. Okay. Then duration. In duration, no. Panchayati Raj institutions duration is typically for 5 years. But it can be dissolved before 5 years. If it gets dissolved, there has to be conduction of fresh elections before 6 months from the date of dissolution. Okay, within 6 months they have to conduct the election here. Now, or if the tenure of the Panchayati Raj institution is about to end here, they have to conduct the election before 5 years. Before this 5 years only they have to conduct election, not after this 5 years. Okay, then this suppose after the dissolution a new panchayati gets established somewhere here, and then that new panchayati will be holding a remainder of the tenure, not the full tenure. They won't get the full 5-year tenure. They'll just hold the remainder of the tenure. All right, now let's say the Panchayati Raj institutions get dissolved at this point of time, when the time duration between their dissolution and the end of their term is less than 6 months. Then at that condition, no need to hold any election for new panchayat. Okay. Then disqualifications. If disqualified under any law for the time being, there are like 2 conditions for disqualifications. a member can be disqualified under any law for the time being for the purpose of state legislative assembly elections, or a member can be disqualified under any state law. Okay. Now this question of disqualification will be done only by such an authority determined by the state legislative assembly, and no person will be disqualified if they are between 21 to 25 years. No person will be disqualified here. Okay. Then state election commission. State election commission will be was established by this act. What it does superintendence, direction and control for the preparation of electoral roll and conduction of elections to the panchayats. This superintendence, direction and control is vested in the state election commissioner. Now state election commissioner is appointed by the governor, and the conditions of service in the tenure of the commissioner, state election commissioner, is determined by the governor here, not parliament, not the state legislature assembly. It's the governor here. Then state election commissioner is removed in the same manner as that of the high court judge. How is the high court judge removed? Removed by the president on the recommendations of the parliament. Same way state election commission is removed. Then state legislature will make provisions for the elections to panchayats. Here no, in MCQ they can give state election commission will make provisions for election to panchayats. That will be wrong. It is state legislatures which will make provisions for elections to panchayats. Then powers and functions. State legislative assembly endows some powers and functions as may be necessary to panchayats in order to function as units of self-government. Now this state legislative assembly can make provisions for the devolution of these powers and functions with respect to preparation of plans for economic development, social justice, and also with respect to implementation of schemes of economic development and social justice, or with respect to any of the 29 subjects in the 11th schedule. Okay, then finances. State legislative assembly may authorize panchayat to levy, collect or appropriate taxes, duties, tolls, fees. Okay, it can tell the panchayats to collect that. Also, it can assign the panchayats the taxes, duties and tolls, fees which are collected by the state government, collected and levied by the state government. It can assign it to the panchayats. Then it can provide grants. State legislative assembly can provide grants from the consolidated fund of the state to the panchayats. Then state government can also provide for constitution of funds for crediting all the money of the panchayats. Okay, fund बनाएंगे इसमें. Then finance commission. Finance commission here, governor, state finance commission and state legislative assembly. So governor will constitute this state finance commission every 5 years, and state finance commission will review the financial positions of the panchayats and give recommendations to the governor. Now this governor will place his recommendations before the state legislative assembly. Okay, now state legislative assembly will provide for the composition, qualification and manner of selection for the state finance commission. And also the central finance commission will suggest measures to increase the consolidated fund of state to supplement or increase the resources of panchayats. Okay, it will give some measures to this state legislative assembly. After all this, devolution will happen. And these recommendations are not binding, just recommendatory. Okay, now these recommendations, regarding this recommendation, there are some principles that should govern, which are related with distribution of net proceeds of states between state and panchayat. Recommendations should be based on this distribution of net proceeds, how it has to be distributed. Then determination of tax, duties, tolls, fees to be assigned to panchayats. Okay, how much tax should be assigned to panchayats? That also will be one of the recommendations. Then grants in aid from the consolidated fund of states. How much grants to give to give to the state Panchayati Raj institutions, and also what measures to take to improve the financial positions of panchayats. All these recommendations will be given to the governor, and the governor will place it to the state legislative assembly. And the state legislative assembly will withdraw funds from the consolidated fund of India and distribute it to the panchayats. Then audit of accounts. It has to be maintained by panchayats. This audit of accounts will be provided by the state legislative assembly. Okay, and what about duties? Is Panchayati Raj institutions applicable there also? Answer is yes, but president may direct that this application would be subject to some exceptions and modifications. Okay. Then these Panchayati Raj institutions are exempted in some states and areas. This act does not apply there. Which are these states? Nagaland, Meghalaya, Mizoram, and some other areas like the scheduled areas and tribal areas, hill area of Manipur where district council exists, then Darjeeling district of West Bengal where Darjeeling Gorkha Hill Council exists. In all these areas, this act does not apply. Now, scheduled area and tribal area. Scheduled area may there are 10 scheduled areas. We know no fifth schedule. Fifth schedule areas are scheduled areas. That is these areas. Okay. And these are 6 schedule areas. फिफ्थ शेड्यूल एरियाज में कौन कौन आता है? आंध्र प्रदेश, तेलंगाना, झारखंड, छत्तीसगढ़, गुजरात, हिमाचल प्रदेश, मध्य प्रदेश, महाराष्ट्र, ओडिशा and Rajasthan. And 6 schedule areas, that is tribal areas with autonomous districts. Assam में three we have 3 autonomous districts. Then Meghalaya 3, or Tripura 1 autonomous district, and Mizoram 3 autonomous districts. So in these areas, they are not applicable. However, Parliament can extend this part 9 to these scheduled areas and tribal areas with exceptions and modifications. So Parliament has enacted the PESA Act of 1996. Okay, what is PESA Act? Provisions of Panchayats extension to Scheduled Areas Act. Okay, whatever provisions of Panchayat is there, it will be extended to scheduled areas as well. This is an exception. Okay, then what is the other salient feature of this act? Continuance of existing laws of panchayats. Okay. Now on 24th April 1992, Panchayati Raj institution 73rd amendment was being made. Now what it said is within 1 year time, states have to adopt a new Panchayati Raj, new Panchayati Raj system. Okay, majority of them adopted in 1993 and 1994. I think maybe some exception they made till 1994 they gave time. Okay, now some states already established some Panchayati Raj institution before this date. So what about them? Now there are some state laws related with those panchayats. That state law will continue to be in existence for 1 more year, that is till 14th April 1993. Okay, and what about the tenure of that? Tenure of that shall continue till the expiry of that Panchayati Raj institution, or it can be dissolved sooner by the state legislative assembly. Another feature is bar to interference by courts in electoral matters. What they will not interfere into? They will not interfere into the allotment of seats and validity of any law related with delimitation of constituencies. Okay, validity and allotment cannot be questioned in any court. And no election to any panchayat can be questioned except by an election petition to such an authority provided by state legislative assembly. Okay, only such authority you can go for questioning. Like if you want to question, go to this authority created by state legislative assembly. Then 11th schedule has 29 subjects. Let's see one by one. Just have a glimpse, that's all. Agriculture, land improvement, irrigation, animal husbandry, fisheries, social forestry, minor forest produce, small scale food processing industry, khadi village and cottage industries, then rural housing, drinking water, fuel and fodder, road infrastructure, rural electrification, non-conventional energy, poverty alleviation, education in primary and secondary institutions, training and technical and vocational training, libraries, cultural activities, markets and fairs, health and sanitation, family welfare, social welfare, welfare of weaker section, public distribution system, maintenance of community assets. These are all the 29 subjects mentioned in 11th schedule. Now I discuss now that 73rd Amendment Act as compulsory provisions and voluntary provisions. What are the compulsory provisions? State has to compulsorily organize Gram Sabha in a village. They have to establish Panchayat at village, intermediate, and district level. There has to be direct elections to these levels. There has to be indirect elections of the chairperson at intermediate and district level. There has to be voting rights, and minimum age should be 21 years for contesting of elections. There has to be reservation for SC and ST and women for both membership and chairmanship, chairperson, office of chairperson. Then tenure should be fixed to 5 years, and if it is dissolved, then fresh election should be held within 6 months. Then establish state election commission and establish state finance commission. What are the voluntary provisions? Like, it is discretionary in nature. State can do it or cannot do it. Endow powers and functions to the Gram Sabha. Then manner of election of the chairperson. Then representation of the chairperson in intermediary level. Like, if the chairperson is from the village level, chair is belonging to the village level, then give representation in the intermediate level. Or if he is there in the intermediate level, give representation in the district level. This is the discretion of the state government. Then representation of the chair of intermediate level in the district level, that only what I told. Then give representation of 2 MP and MLA in the panchayats. Then reservation for OBCs. Then granting power and authority to panchayats to behave as autonomous bodies. Then devolution of power for economic development and social justice. Then granting financial powers to collect tax. Then state government, whatever tax they've collected, they have to assign to panchayats. That is also under their discretion. Then grants in aid, discretion. Then constitution of funds. Okay, they can do that as per the discretion. Then PESA Act of 1996. Now, actually, normally Part 9 doesn't apply to 5th schedule areas, but Parliament can extend the provisions of this Act with exemption and modifications. So they enacted the PESA Act of 1996. What is the objective of this Act? It extends Part 9 to scheduled areas. It provides for self-rule for the bulk of the tribal population. Gram Sabha, it makes Gram Sabha as the nucleus of all activities, and provides an administrative framework consistent with the traditional practices. And it safeguards traditional tribal communities. It empowers panchayat tribal requirements and prevents the higher level panchayats to dominate. It prevents this domination over lower level panchayats. Now, what are the features? The law made by the state on the panchayats will be in consonance with the traditions of the community. Okay. Then in the village, there will be either habitations or group of habitations, or there will be a hamlet or a group of hamlet. They will manage the affairs and in accordance with their traditions. Okay. Then every village will have a Gram Sabha, and that Gram Sabha will consist of those kind of people whose electoral role are mentioned in the village. Okay. Then the Gram Sabha will be made competent. Competent for what? To safeguard and preserve the traditions, customs, cultural identity, community resources, and also competent for dispute resolution. Gram Sabha will be made competent. Then every Gram Sabha, before implementation of any plan, has to take approval. I mean, you have to take approval of the Gram Sabha for any socio-economic development. Okay, and Gram Sabha will be responsible for identifying beneficiaries for poverty alleviation and other programs. And every panchayat at the village level will obtain a certification from the Gram Sabha for utilization of funds. So this means that panchayat is a smaller body as compared to Gram Sabha. Okay, so Panchayat will take permission from the will take a certification from the Gram Sabha in order to utilize funds. Then reservation in the Panchayat proportion to the population of such community. Now we are talking about scheduled areas, no? In scheduled areas there will be ST populations or SC populations majorly. So reservation will be provided depending on what kind of community you want to give reservation to, either ST or SC. But for SC people, no, more than half of the seats are reserved. For any other community in the scheduled areas, they will do depending on the proportion to the population. Then chairpersons at all levels, village, intermediate, and district levels, will be held only by scheduled tribes. Okay, then state governments will nominate scheduled tribes if there is no representation in intermediary or district levels, provided that it has to be less than 1/10 of the members. Let's say this is the intermediary level, 1/10 will be reserved for ST, and this is the district level, 1/10 will be reserved for ST. Means nomination will happen here, less than 1/10. Then planning and management of minor water bodies will be done by Panchayat at all levels, village, intermediate, and district levels. Then Gram Sabha or Panchayat is consulted at all levels for the acquisition of land for development projects, or when resettling or rehabilitation of persons affected by such projects are happening. At that point of time also, Gram Sabha Panchayats are consulted. But actual planning and implementation is done and coordinated by state level. Okay, then recommendations of Gram Sabha and Panchayat at all levels is mandatory for what? For granting of prospecting license. Prospecting license, tell me what is it? It's a homework for you. And also it is mandatory to get recommendation of the Gram Sabha and Panchayat for mining lease to extract minor minerals. Okay, then prior recommendations of the Gram Sabha or Panchayat at all levels is mandatory for grant of concession in order to exploit minor minerals for auction, by auction. Okay, then state legislative assembly, state government can grant powers to the Panchayat and Gram Sabha at all levels. However, there are some specific powers which are given to these Panchayats and Gram Sabhas, which are they: power to enforce prohibition or regulate, restrict sale of consumption of intoxicant, then ownership of minor forest produce, then power to prevent alienation of land and restore any land which is unlawfully acquired, then power to manage village markets, then money lending, then control institutions and functionaries in all social sectors, then control local plants and resources, basically tribal subplans is to develop the tribal areas. So these are the specific powers which are given exclusively to Panchayats and or Gram Sabhas. Then state law, any law made by the state, it will contain safeguards so that the higher level Panchayats do not assume the powers and authority of lower level Panchayats. So basically it prevents the domination of this higher level Panchayats. Okay, so that completes the Panchayat Raj system. So thank you. I hope you understood everything. Do give your feedback. Thank you.